also regulatory claims from agencies like Cal OSHA or the National Labor Relations Board. So first off, regarding employee claims, the biggest type of claims you're going to see from your employees are those surrounding workplace safety. In California, the workers' compensation system is actually a no-fault system, and the employer doesn't have to do anything wrong for an employee in order to get benefits. If the employee's injury or illness was related to work, they're actually going to get benefits and they're going to get compensated for their injury. Now, when COVID-19 first came out and we first started hearing about COVID-19, nobody was really too concerned about workers' compensation as it related to COVID-19 because it was very, very difficult to actually pinpoint where an individual contracted the virus. However, in the beginning of May, Governor Newsom mandated that any type of injury, any type of a COVID-19 infection is presumed to have occurred at the workplace, and that employee is going to be eligible for workers' compensation benefits. Now, this is just a presumption that this injury was contracted at the workplace. The employer is permitted to present evidence showing that the employee may have contracted the injury elsewhere. At this point, since this really hasn't been litigated yet, it's kind of up in the air what type of evidence an employer is going to have to show that the employee contracted the virus elsewhere. This presumption applies if the employee had actually been at the workplace or done work for the employer in the last 14 days of them contracting the virus. Now, since most people actually recover from the virus very quickly, within a short period of time, this may not necessarily have much impact. It may not have much of a financial impact on an employer's mod rate for workers' comp. And the other thing is that for the first 2 weeks that an employee is out on this type of workers' compensation claim, Governor Newsom's order states that they are going to have to look to the federal paid sick leave before they can get temporary disability benefits under the workers' comp system. So again, it's not necessarily going to have much of a financial impact on employers. However, in addition to this no-fault system in California, employees may also pursue something called a serious and willful claim at the Workers' Comp Appeals Board, and they typically allege that their employer affirmatively did something wrong, or their employer affirmatively or did not do something that they were supposed to do. And this is what caused the injury. There's no insurance coverage for this type of claim. The employer has to pay these penalties and pay the costs of defense out of their own pocket. And if this type of allegation is proven, the employer has to pay an additional 50% of whatever other benefits the employee is going to be receiving for their injury. So, for example, assuming a worst case situation of a COVID-19 infection where the employee is actually hospitalized, if their medical expenses and lost wages and legal and medical fees were $100,000 and they actually prove this serious and willful claim, the employer is going to have to pay an additional $50,000 as a penalty to the employee. So these situations, we anticipate these to become a little bit more common based on the COVID-19 virus. Now, the serious and willful claims, they're based on either a violation of a safety order, such as the Cal OSHA standards, or it's based on the failure of an employer to provide a safe workplace. we have seen there's cases across the United States where the employee alleges that the employer has failed to do certain things. For example, they've failed to screen employees, they've failed to implement and enforce social distancing policies, and the biggest one is that they have failed to implement the specific CDC and Cal OSHA and local shelter-in-place requirements. And they say that the employer has failed to do these things, and this failure has caused them to contract the virus. And this is the basis for these serious and willful claims that we expect to be seeing over the next few months. For example, down in Vernon, California, there was a big outbreak of COVID-19 at the Farmer John's plant down there. And we're expecting to see these types of serious and willful claims. And a comment about the Cal OSHA standards. If Cal OSHA has actually come out and cited you for violating their standards surrounding COVID-19 and you actually have a citation, that is pretty much proof that that you have engaged in serious and willful conduct sufficient for this enhanced benefits and penalty to be paid. The other types of claims that we're expecting to see are third-party claims, and these would be coming from your clients, your vendors, and possibly anybody who would be walking on your job site. And these third-party claims are based on a negligence theory. And under this particular theory, the claim is that a reasonable person would have acted in a particular way. You did not act as a reasonable person would have acted. And the individual contracted the COVID-19 infection, which was caused by your failure to act. And sometimes in these types of negligence cases, the standard of a reasonable person is kind of a little amorphous. It's kind of difficult to grasp. But because now there are so many guidelines and standards that businesses and construction companies need to comply with, the standard of a reasonable person is going to be very easy to meet. If you did not comply with all the orders, then you didn't act as a reasonable person would have acted in that situation. The big thing with these third-party negligence claims is that causation is still always going to be an issue. It's unlike now in California with the presumption for workers' compensation. There is no presumption regarding third-party claims, and the individual is going to have to prove that when they contracted COVID-19, it was because of something that you failed to do, and that's still a very difficult standard. There's currently a case out of Texas where an employee's family is suing Walmart for wrongful death based on their failure to screen, their failure to implement social distancing requirements, their failure to clean Walmart. And everybody's kind of looking at that case a little bit closely because it's going to actually come down as to what the causation issue was. Did this individual really contract COVID-19 at work? And was it really, did all of Walmart's failures to do certain things, did it really cause this particular infection? So we're kind of looking at that case to see how it's going to come down. The regulatory agency claims that, and I shouldn't really call them claims, they're really enforcement issues, is going to be from Cal OSHA, violations of their safety standards. The National Labor Relations Board is the federal agency that is charged with enforcing the National Labor Relations Act, which has to do with concerted activity amongst employees. I'm going to touch on that a little bit later, but they have been getting many complaints since COVID-19 regarding discipline over safety issues. And then the labor commissioner is involved in a lot of this, particularly regarding wage and hour issues as it relates to off the clock work and working at home. So we're expecting to see some of that. So the big thing is how these cases are going to occur, and employees are going to file claims, third parties are going to file claims. And how do we protect ourselves against those types of claims? The biggest thing is that you absolutely need to have a written COVID-19 plan. And this plan needs to set forth who in your organization is responsible for implementation of this plan. The plan needs to include social distancing requirements. It needs to include what specifically your plan of action is if you have an employee who tests positive for COVID-19 or who's exhibiting COVID-19 signs of COVID-19. This written plan, once you've developed it, and in a couple of slides, I have resources. There's resources on the internet regarding how to develop these written plans. Smith Dollar has a template for this written plan. If you'd like, you can email us for it and we can provide it to you. But this written plan needs to be given to your employees, just as you provide your employees with your handbook and your handbook updates on a regular basis. The other thing to protect yourself is certainly to update your IIPP, which stands for your Injury and Illness Prevention Plan. Cal OSHA has specifically stated on their website that it is now mandatory for all employers to revise their IIP plans to include COVID-19 and what your implementation is to prevent contracting COVID-19 for your employees. For those of you who don't have an IIP plan, Cal OSHA's website has a template that you can walk through and you answer questions and they develop a plan for you. But one of the things about the IIP plan is that every employer is required to have one. And that particular plan contains information as to who in your organization is responsible for safety, how you communicate safety to your employees, what your training procedures are, and how you document these procedures, and also how you actually identify new hazards in the workplace. And COVID-19 is a new hazard in the workplace. One of the things about an IIP plan is that when a Cal OSHA inspector comes out to your workplace in response to a complaint or in response to an injury, this is one of the very first documents that they ask for. And if they're investigating the injury and there's no other safety standard that was violated which caused the injury, they will cite you for an inadequate IIP plan. They will basically say that you failed to recognize this particular hazard, which is what injured the employee, and because there's no other safety standard that we can identify that you violated, we're just going to put it under the catch-all of an inadequate IIP plan. The reason why this is so important is because once they cite you for anything, including that, once again, that is going to be evidence that you violated a safety order, and any employee's serious and willful claim is going to be very, very easy to prove. The other thing about the written plans is that employers absolutely need to comply with the guidelines that have been put forth by the CDC, Cal OSHA, and of course, Sonoma County. Sonoma County has a social distancing protocol that every business who is operating needs to comply with. There is a specific list of requirements for the construction industry. And the construction industry is required to incorporate these field safety requirements into their social distancing protocol. The social distancing protocol needs to be posted at the entrance to each facility. For a construction site, it is going to have to be posted at the entry to the site. If you're doing work at a residential home, it would have to be posted at the entrance to that home. And your employee who is actually at there needs to have a copy of this social distancing protocol, which incorporates the field safety requirements. So if there's any inspector or anybody from the county or the city who comes onto the site, they have the authority to ask for that protocol, and your employee has to obviously provide it to them. So specific to these construction field safety requirements is an interesting is something a little bit interesting. Each job has to have designated a site safety representative. And this is the individual who is going to be responsible for implementing the requirements. And this is the person who is going to be responsible for communicating with whatever official person is out at the job site. And it includes a daily screening protocol for employees. And this daily screening protocol is typically a questionnaire as to whether the employees have been exposed to anybody with a positive COVID-19 or whether they're experiencing symptoms. And temperature checks are not required. Employees do not have to check employees' temperature. However, that is one of the questions as to whether they are experiencing a temperature above 100 degrees. As of, or coming on June 1st, which is Monday, Sonoma County Public Health has just updated their one of their orders. And beginning June 1st, each employee and employer is required to download an app on their phone, and it's specifically for COVID-19 testing. And the employee is required to put in input information regarding the who their employer is, what the zip code of their employer is, and their age, and what type of industry their employer is, whether it's construction or professional services or restaurant. And the employee is required to answer a series of questions, including do they have a temperature above 100.4, and have they been exposed to anybody with COVID-19, and whether they're experiencing any symptoms. Once the employee goes through those questions and everything checks out, they get the app turns to a page that they get a badge that clears them to continue to work, and they have to show that badge to their employer. The employer is required, when they set up their app, to put in additional information, and they're required to then, once each employee provides this screening information to the employer is required to forward this information to the public health department. This is a little unprecedented. Sonoma County assures everybody that there is no location tracking at all. and that there is no identifying information at all. And this is something that has to be done on a daily basis before employees are permitted to work. One of the things that comes up in this is what happens if an employee does not have a cell phone, because there's people out there who just don't have cell phones. And Sonoma County's response to that was, well, then they are allowed to use the app on their employer's phone to answer these questions. Another question that comes up is who pays for these employees to go through this whole screening process? And Sonoma County says, well, it's only going to take about 30 seconds. It kind of remains to be seen whether we're going to be seeing wage and hour lawsuits coming out of this for the additional time that employees are required to go through this screening protocol. The other point about these field safety requirements is that everybody's required to have a code of safety practices for their employees, and they need to actually give their employees this code of safety practices. Regarding an employee filing a lawsuit, or even an inspector coming on site to a job, or a third party filing a lawsuit, employees tend to file lawsuits when they think that either something's not fair or that the employer is not doing enough to address a particular situation. And so whatever an employer can do to address that is going to go a long way towards preventing claims. So for example, these requirements of having a social distancing protocol on site, and for having these construction field safety requirements, and for having signs posted regarding COVID-19, and having hand washing stations available. A lot of this has to do with optics. If an employee sees that these practices are being implemented, they're less likely to complain. They see that the employer is taking this situation seriously. If an inspector or an investigator came onto the job site and they see that you have that they're not allowed on the job site until they pass this entry protocol, and they see that you have signs posted and you have your social distancing policy there, they're less likely to investigate any further. They see that, they observe with their eyes, and they see that everything looks okay. Same for a third party. The third party is more likely just to go on to the next people who do not have any of this, these safeguards in place. So a lot of this is optics. So sample plans, when this webinar is over, Mary will send you this so you know where to find it. We have a document, it's specific to construction, and what it has done is that it's incorporated the Sonoma County construction orders with the Cal OSHA, the CDC, and the other Northern Bay County orders as it relates to construction. And it's incorporated them into like a 5-page guidance with posters that you can use. Smith Dollar did not develop this. A law firm that we work with in San Francisco developed this, and they gave us, their permission that we can disseminate it and give it out to the NCCA. So other employee claims that we're going to see are claims surrounding the leave laws. Under the Families First Coronavirus Response Act, employers are required to give up to 80 hours of paid sick leave for specific types of claims. This is kind of a little bit fraught with danger because there are only specific reasons why an employer can actually give those claims, and there's payroll tax credits available for that. We're also seeing claims surrounding FMLA and CFRA leave. For those employers who are over 50, who have over 50 employees, these are the statutes that are going to be applicable. Under these statutes, COVID-19 is probably going to be considered a serious health condition, which is going to trigger leave under these two statutes. Also, if an employee is required to care for an immediate family member who's suffering from COVID-19 or symptoms, these statutes are going to be applicable. Regarding paid sick leave, and I'm not talking about the federal emergency paid sick leave, I'm talking about the California sick leave. First, everybody knows that if an employee wants to take sick leave for any of those reasons set forth in the FFCRA, that an employer cannot force them to take their California paid sick leave first. However, once the 80 hours under the federal law is exhausted, employees are permitted, obviously, to take their paid sick leave under California law. The other type of leave that an employee is eligible to take for COVID-19 related issues would be the leave as a reasonable accommodation under the Americans with Disabilities Act and the California Fair Employment and Housing Act. Now, COVID-19 is a transitory illness. Most people recover within 2 weeks. And in and of itself, it's probably not going to be considered to be a disability. However, if there is an employee who is at high risk for severe COVID-19 symptoms, for example, employees who are over the age of 65 and have heart disease or lung disease or diabetes, those underlying conditions are probably going to qualify them to take leave under the ADA. In those circumstances, you would probably be required to grant them a leave of absence as a reasonable accommodation under those statutes for their disability. And if that is the case, then you would go through your company's typical process of requiring certification from their medical doctor and discussing the length of the leave and exactly what it is they need. The other type of discrimination claims that you have to watch out for is that because the virus originated in China, there's the potential for employees to engage in some type of ethnic discrimination and harassment towards Asian employees. And you need to watch out for that. And the other issue is that the Press Democrat had an article over the weekend discussing how COVID-19 is disproportionately affecting the Latino community, and the percentages of the individuals who are positive for COVID-19 there's a huge percentage in the Latino community which doesn't track with the percentages of Latinos in the community as whole. So that's another thing that you kind of need to watch out for, that people are not discriminating or harassing certain ethnic groups because of their fear of COVID-19. One of the other issues is retaliation claims. Many of my clients have gotten complaints from their employees regarding safety, especially when COVID-19 was fairly new back in late March and April, and where employees felt that their employers were not doing enough to protect them from contracting COVID-19. And employers are cautioned against retaliating against employees for making these types of complaints, even if these complaints seem a little bit off the wall and spurious. And if the employer feels that they have done absolutely everything they can do to protect against COVID-19, including implementing all the safety regulations, and the employee yet is still complaining, I would caution you to take it seriously. Under the National Labor Relations Act, concerted activity is protected. And what I mean by that is that if 2 or more employees get together to bring some type of a complaint to the employer, or even if it's one employee who's speaking on behalf of other employees, their actions are protected by the National Labor Relations Act. And this goes even if you don't have a union or a collective bargaining agreement. There are currently 3 cases now before the National Labor Relations Board alleging an unfair labor practice because the employer has disciplined and or terminated an employee who alleges that he was speaking on behalf of other employees when he made his safety complaints. So that's going to be a big one. And then, of course, I touched on before the wage and hour claims. And this has to do with off-the-clock work, the additional time employees are required to stand around to be screened before they're permitted to clock in. Under federal law, that additional time is probably not going to be compensated, but under California law, it's probably going to be compensated, and the better practice is to pay your employees for that additional time. The other type of wage and hour claim that we're going to be seeing is employees who are working remotely at their homes. We're looking at seeing claims regarding meal and rest periods because they're still entitled to those even if they are working at home. And we're probably also going to be seeing claims regarding overtime and business reimbursement claims. And I think that concludes my portion. And as I said, Rachel is going to talk about the PPP loan. And I know I have questions that I've gotten emailed to me regarding these employment issues. So when Rachel is done, we will answer those questions and take whatever other additional questions you have.
Thank you.
Hello.
Hey, Rachel.
So I'm going to talk about the PPP loans, and I'm not going to talk about applying for PPP loans. If you would like one, you have another 3 days while the period is open. So you should jump in and get them. I know that a lot of borrowers have returned funds, and there's actually the balance in the PPP fund is going up, not down at this point in time, because the applications have slowed down a lot, and with all the returns because of the safe harbor period that they allowed to return your funds, a lot of people returned them. So there is money available if people are still looking for PPP loans. So there's a couple issues I'm going to talk about. I'm going to talk about how to use your proceeds, what you can use it for, and then I'm going to go through the forgiveness process and the documentation that you need to keep with regards to your forgiveness. First of all, you can use the proceeds for anything that you can use a regular small business 7A loan for. The restrictions on what it can be used for really relate to forgiveness, not to the use of the loan itself. So You can use the 7A loan for working capital to buy inventory, along with the specific things that you can use it for under the forgiveness section of the statute. The statute itself allows additional uses, additional specific uses and forgiveness during what it refers to as a covered period, which is between February 15th, 2020 and June 30th, 2020. We're actually expecting there's some legislation up before the House and before the Senate where they're trying to expand that 8-week period of time where you can use the funds and get it forgiven. But in order to get it forgiven, what you can use it for is for payroll costs. So the same things that you based your application on: wages, salaries, commissions, tips, health insurance, state employment taxes. So all those expenses around employing a person are forgivable. But that has to be 75% ultimately of the amount that's forgiven. And now that they've come out with the application, we're a lot clearer. I did a webinar on this a couple weeks ago, and it was a lot of speculation about how the formulas were going to work. We actually now have them. And then you can use the proceeds and have them forgiven on mortgage interest. So you can't pay the principal on a mortgage, but if you had a mortgage that was in place on business property before February 15th, 2020, you can get the interest you pay on that mortgage forgiven. Your rent on your or lease on your business premises, as well as other property. So it's real or personal property. So if you have a lease on a copy machine or a vehicle or you can use the proceeds for that. So for debt payments. And then utilities. So the utilities is actually pretty expansive and includes transportation costs as well as internet, cell phones, telephones. So it is pretty expansive about what you can use it for as far as utilities go. It does state that 75% has to be payroll, but if you spend more than 25% on non-payroll costs, because of the way the forgiveness calculation is structured, you actually may get more than 75% or more than 25% of your non-payroll costs forgiven ultimately. So don't artificially limit your amounts or the amounts that you look at or put down on your application based upon that 25%, because the formula works its way through. So as far as forgiveness goes, the forgiveness period of time that they look at is 8 weeks. That 8 weeks begins on the day that your loan was funded. Now, the forgiveness section allows you to look at your payroll in a different way if you would like, for administrative convenience, because your payroll period is not actually necessarily going to start on the day that you get your PPP funds. So you can go to the beginning of your next payroll and start your payroll 8-week period. It's 56 days exactly, as of the day of the beginning of your next payroll period after you get the loan proceeds. And they call that the alternate covered period. And it would run for 56 days. So say you got your loan on April 26th, but your payroll period starts May 1. You can start looking at that period on May 1. I would look at it both ways, both the actual 56 and the alternate payroll period, just to see which one gives you the better amount of forgiveness. You may have more employees later on, especially if you had furloughed people and brought them back, later on or after you got your money. And you can only use that alternate period if your payroll is biweekly or more frequently. So at our offices, we have a semi-monthly payroll period. We pay people twice a month. We don't have the option to use that. It either has to be weekly or biweekly, or at least more frequently than biweekly, which is every 2 weeks. And then during that period of time, it's amounts incurred or paid for eligible expenses. And the guidance has been pretty interesting because we had assumed that it would run the same way payroll did. So if it's incurred during that time period, like, you have to start looking at the amount of rent that you paid on April 26th. If that's the day you got, like, divide your rent by so many days and it's only that time period. But actually, if you pay your April rent in May, you could include it in there, because as far as the early period goes, it's amounts that you pay during the period, but then the cutoff date for those payments is the last day of that 56-day period. So even you can pay it later on. So it's the next billing cycle. So say if your rent isn't due and you pay it wouldn't be rent, it would be something else, but you pay in arrears, like your utilities, and the utilities are for all of July, and your cutoff period, your last day is July 26th. You could use the utility costs from July 1st through July 26th, even though they weren't paid until the next regular billing cycle. So I'm going to kind of go through some parts of the application for forgiveness. And the one thing I'll tell you is that when you start looking at the application for forgiveness, start at the back of it. Don't start at the front of it. So you want to start at, there's the application, there's Schedule A, and there's a Schedule A worksheet. Start on the worksheet. So what you do is you go and you get all the gross pay that you paid to your employees. That includes all the taxes that they paid to the federal government, state, all their health stuff. So actual, if you pay them $10 an hour, it's that $10 an hour, the whole amount. You can also include there any paid leave, commissions that you pay, tips, and that's either based on 2019 tips or it's based on a reasonable estimation of tips if you don't have that information. And then you also can use allowances for dismissal or separation. So if you do terminate somebody and you pay them separation pay, you can include that within the gross pay that you paid. It's only applicable to U.S. resident employees. So if you have overseas employees, you don't count them. And the maximum for any one employee is $15,385 within that 56-day period. And that's an annualized $100,000 a year. And I pulled out the two tables on the Schedule A worksheet, because this is where you actually list every one of your employees and you put in the last four of their social security number under employee identifier. There's two tables. The first one is for employees who made less than $100,000 in 2019 annualized, or who were not employed by you in 2019. And the second table is for people who made over $100,000 annualized in 2019. And that gross pay section is what you put in the cash compensation column on both of those. I have the bottom one yellowed out, but I'm not very good with the highlighter on the Snippy tool, so I only did on one. Then you look at the salary reduction, because if you reduce your employees' salaries after you get the money, then or after February 15th, then you take a reduction. You don't get as much money forgiven. You only use the employees for this who are in that table one, so they make less than $100,000 a year. And their salary gets reduced, and it's a complex formula, so I'm not really going to try and explain it in a way you'll understand it. You'll see it on the application. If you reduce their average annual salary by more than 25%, then you take a hit on your forgiveness. And the look back period is January 1st through March 31st. You look at the average annual salary for that time period versus the average annual salary for the time period later, for the later time period. And if there's a reduction of more than 25%, that's when this comes into play. There's kind of two time periods. You either compare it at February 15th to the salary and wages between February 15th and April 26th. And if the amount between February 15th and April 26th is equal to or greater than what you were paying them on February 15th, you don't have a reduction. If it isn't, you compare it then, the 2/15 salary to 6/30/2020. And if it's equal or greater at 6/30, there's no reduction. So as long as you bring your employees back up to the amount they were making on February 15th by June 30th, then you do not take a reduction for any reduction in salary. The forgiveness amount that's reduced is only the amount of salary reduction more than 25%. So you can reduce all your employees' salaries by 25% and you don't have a reduction. It's only when you're more than that, and it's only the percentage difference. And the guidance that just came out said that that you don't get the salary reduction hit when it's just attributable to a full-time employee reduction. But I don't see anywhere in the application where that actually gets applied. It looks like if you say you terminate somebody completely, you would have a full-time employee reduction, and it looks like you'd also have a salary reduction based upon the way the application is worded right now. So on the Schedule A worksheet, you have to then look to see whether or not you have a reduction in your forgiveness amount based on reducing the number of your full-time employees. So the way you calculate that, and again, it's only on, no, it's on both. It's on both employees over and under $100,000 a year. And it's this average FTE column that I have in yellow. So you figure out on a weekly basis or a payroll period basis, the average hours, well, the average hours you paid the employee, and it's on employee by employee basis, the average hour you paid them per week. Then you divide it by 40, because it's 40 hours per week, and you round it to the nearest 10th. Now that should come up to 1. So if you have a 40-hour-a-week employee, or a 40-hour-a-week, 48-hour-a-week, or somebody works 80 hours a week, that's 1. One full-time employee works 40 hours a week. It can be less than that. So if they work 20 hours a week, it would be 0.5. And if they work 30 hours a week, it would be 0.75. And that's the percentage of the full-time employee that that person is. Now, then when you add them all up, you figure out how many full-time employees that you have, 1.5 or 10.726. You have an option to make it easier for you to use 1. You use the number 1 for every employee who works 40 hours or more, and 0.5 for every employee who works less than 40 hours. As with all of the calculations in this where you have an option, I would figure it both ways. And in this case, you want to go with the lowest number that it comes up with, because this is it's a reduction overall in the amount of your forgiveness. You actually multiply by any reduction, and you get a reduction on your full amount of forgiveness based on the FTE. I'll tell you that the FTE calculation, the FTE reduction is way worse than the salary reduction. The salary reduction is dollar for dollar. If you pay somebody, $200 under the 25% reduction, you get $200 off of your forgiveness. If you reduce your FTEs by 20%, 20% comes off the top of your forgiveness. So the FTE forgiveness issue is much more significant than the salary reduction. Again, as long as you bring them all back, or you bring back the same number of FTEs by June 30th, you don't have a reduction. So the employer in this case gets to choose, as long as you're not a seasonal employee, you get to choose one of 2 look-back periods to determine whether or not your full-time employees now are less than what your full-time employees were before. You have to have something to compare it to. So you have a choice of looking at 2 periods. One is February 15th, 2019 to June 30th, 2019. And the other is January 1st, 2020 to February 29th, 2020. Calculate your FTEs for both of those periods and go with the lowest one, because that's as far up as you need to go. So if you averaged 10 employees last year and you averaged 20 in the look back period this year, you're going to want to use the 10, so that if you ended up with 12, you're over it and you don't have that reduction. So it is worth it to run the full-time employee numbers for both of those periods. You have to use the same formula on both sections, though. Use the same formula that I talked about on the last slide for the look back period as well, but you have to use the same method. So if you use that number 1 for a full-time employee and 0.5 for somebody who works 39 hours a week, you would use that same method of determining it under both of the calculations. So then you go and you add together both those, the full-time employees you had in table 1 and table 2, people who make less than $100,000 and people who made more than $100,000, and you divide it by the average FTEs from your chosen look back period. So you'll come up with a percentage or decimal point of a number. And that's going to be the amount that you have to multiply your full forgiveness amount. So all of your payroll, along with your mortgage payments, along with your utility payments, along with your rent payments, that whole number, you multiply that percentage by. So if you have a 50% reduction in FTEs, you will have a 50% reduction in the full amount of your forgiveness. So you don't get a FTE reduction, and this is new, in cases where you made a good faith written offer to rehire during the covered period, which was rejected. Now, if you offered to bring somebody back before you got your money, make sure that you give them a written offer to rehire them after you get your money, because the offer has to be made during the covered period, which starts on the day that you get your money and it ends 56 days later. You have to offer them the same salary and the same hours as they had in the last pay period that they worked prior to the time that their salary was reduced or they were furloughed. You also don't get an FTE reduction if you fired somebody for cause, and you will want to keep documentation of that. If they voluntarily resigned or they voluntarily requested and received a reduction in hours. So anybody who decides they don't want to work for you, or if you have some real reason to fire them, then you're not going to get an FTE reduction. But this thing with the good faith written offer, it has caused a lot of concern with people because employees are on unemployment. Maybe not so much in the construction industry as in industries like the restaurant industry, where people are working for minimum wage or not much more, and they're making a lot more on unemployment right now. Their employees don't want to come back. And they're really in this position where, you know, you have this PPE, you have to spend it. You're not going to get the money forgiven, but your employees won't come back. So you have to make, if you want to get forgiven, you have to make the good faith written offer to rehire them. They have to reject it. You need to keep documentation of it. And you have to inform the state unemployment office that they have rejected that offer within 30 days of the date that they reject it. And that's new in the guidance. There's information on the SBA site as to how to do that. The thing about the forgiveness, though, is that even if employees reject the offer and so they don't come back and you end up with no employees, you're not going to spend the money. So it's not going to get forgiven anyway. So they're not going to be entitled to unemployment because you didn't offer that, because they didn't take a job that was offered. And you're not going to get any forgiveness because you don't pay out the money. So it really is kind of this tough catch-22 situation. You still have to pay the money out in order to get it forgiven. So the next step in calculating your forgiveness is to pull together all the amounts that you have for eligible payroll. So again, you're using the covered period or you're using that alternate covered period, and you're looking at all cash and non-cash items that you pay to employees. So wages, salaries, commissions, tips. Again, use the gross pay. You can use the employer contributions for employee health insurance, contributions to employee retirement plans, and state and local taxes, as long as they're being paid by the employer, not the employee. And then as far as the amounts paid to owner employees, self-employed and general partners, it's 8/52 of their applicable compensation capped at $15,385. And I'll just go into that a little bit more. So 8/52 is 8 out of 52 weeks worth of pay. So for an owner employee of a company, you use their 2019 cash compensation along with their employer retirement and healthcare contributions. If you're a Schedule C filer, it's 2019 net profit, and they don't get to take into account retirement and healthcare because that comes off the net profit amount. And then the general partners, or because they pay it outside of that anyway. And then with general partners, it's the 2019 earnings from self-employment, and it's reduced by Section 179 expenses unreimbursed partnership expenses, and depletion on oil and gas properties. I don't know if a lot of people on this call probably have those expenses. And then you multiply that by 0.9235, which is to take into account the self-employment tax, which you would otherwise pay. Like an employer is not entitled to get PPP forgiveness on federal income taxes that they pay, or so FICA or Medicare. And then this just grosses that up for self-employed. So then you look at your non-payroll amounts. So again, it's business mortgage interest. You cannot make advance payments of business mortgage interest. Business rent or leases, whether it's real or personal property. So again, your car, your copy machine, all that, and business utilities. The contracts for all of these must have been in place on February 15th. So you can't go out and enter into a new lease or a new contract or a new mortgage and expect it to be forgiven. And then it has to be paid during the covered period, even if it was incurred in a prior period, or incurred during the covered period and paid on or before the next regular billing date. But the amount that you get to cover ends on the last day of the covered period. I went over that a little bit earlier, so hopefully that's clear. Now, the formula to determine how much is ultimately forgiven. First, you have to calculate your expenses less the salary or FTE reduction, because that's one of the options that you have. So you add all your eligible payroll and non-payroll, you subtract any amount that is reduced because of the salary reductions, and then you multiply it by the FTE reduction percentage. So again, if you have 50% reduction in employees, you have a 50% reduction in the amount of your forgiveness. And then your forgiveness, they look at 3 different numbers to decide what your forgiveness amount, and it's the smallest amount of the 3. So it's either that number that I just talked about, your expenses less the salary and FTE reductions, an amount that's 75% of your payroll, or your PPP loan amount. To figure out what amount is 75% of your payroll, you take that payroll costs that we talked about, the gross salaries, the health insurance, the state taxes, that whole number. And if you do that divided by 0.75, it'll give you a bigger number. And that number is what that amount is. That's the payroll and non-payroll cost cap based on 75% of your payroll. So just a very, very simple, a couple very, very simple examples, one of salary reduction and one of FTE reduction. And in both of these, we're going to assume that you have 3 employees as of February 15th, and that you paid them each $3,000 a month, and that you applied for and received $22,500 in PPE. Notice I didn't put any health insurance in there or taxes or anything. Very simple. So 22,500 is 9,000, which is 3 employees times $3,000 a month times 2.5, which is what you got for PP&E. Your payroll times 2.5 or 2.5. So in this example, let's say that you rehired 2 of your employees and you paid them $3,000 a month. So you didn't rehire one of them at all. That means you retained 67% of your workforce. So you had 3 employees, you got rid of 1, you kept 2, and you paid them just as much as you did before. So it's 2 employees, $3,000 a month times 2 months, about $12,000 on payroll. And let's say you paid $10,500 on rent and utilities, which is more than 25% of the amount, the payroll. So your forgiveness would be the lowest of your PPP loan amount, which is $22,500, $16,000. So $16,000 is your expenses, where 75% of that number is payroll. So if you have $12,000 on payroll, $4,000 is the other 25% of that number. So that's $16,000. That's the second option for forgiveness. The third option is applying the FTE reduction. So you take the $22,500 you spend in expenses. Now notice I'm not taking the $16,000. I'm not applying the 75% payroll amount first. That's not what the application requires. You actually take the full amount you spent on payroll, rent, and utilities without regard to that 75% payroll requirement, and you apply your FTE reduction. In this case, you kept 67% of your workforce, so it's times 0.67, which leaves you with $15,075 after application of the FTE reduction. And that is the lowest number of those three numbers. So you would have $15,075 that would be eligible for forgiveness. Now let's do that same one and look at a salary reduction, which is the same in the pocketbook of the employer, but doesn't involve terminating any employees, and it doesn't involve an FTE reduction, just a salary reduction. So assume again, 3 employees, they're each paid $3,000 every 4 weeks, and you get your $22,500 in PPE. So you keep all of your employees on, but you pay them $2,000 a month or every 4 weeks instead of $3,000. So that's a 33% reduction in salaries. Again, let's assume $12,000 on payroll, $10,500 on rent and utilities. So your forgiveness is the lowest of $22,500, which is your PPP loan amount, $16,000, which is exactly the same. It's your expenses where 75% is payroll, or $21,000, which is your expenses of $22,500 plus $1,500. So that's the difference between the, so you reduce your employees by 75%, and that's fine. But then when we reduce them farther than 25%, we have a 33% reduction, we end up having to, it's what, 8 or 9% that, in addition to the 25% that it's been reduced, and so that's what you get docked on it. So it's $500 per employee for the 8 weeks, and you only have a $1,500 reduction. So you would actually get forgiven $21,000 here, even though you spent exactly the same amount. As far as documentation goes, first, really, if you keep your PPP funds in a separate account and write checks for your eligible expenses and payroll, or transfer into your payroll account from it directly for your eligible costs, that's the best thing you can do so you have good records. You have to keep records of your, and you have to submit with your application for forgiveness the number of FTEs during your covered and look back periods. You need to be able to document that. You can do that with payroll records, payroll tax returns, which you also need to submit. Payroll records or bank statements are going to show the compensation to your employees. You need both federal and state payroll tax returns. You're going to need any billing statements from your group health care benefits or for retirement plans, and canceled checks or bank statements, receipts, account statements, other proof that you paid them. So proof that you incurred the costs and what they were, proof of the number of full-time employees, proof of what their salaries were, both in the original periods that you're looking back and in the covered periods, and then proof that you actually paid the amount. As far as sole proprietors and self-employed individuals, they're also going to need, or an alternate, your 2019 Form 1040 Schedule C. And if you have employees, all those same things, payroll reports, healthcare, retirement, and again, canceled checks, receipts, account statements, proof of payment. You're probably also going to want either a bank statement or something that shows that your lease or your mortgage was in place as of February 15th, or actually the lease, mortgage, or a utility statement or utility contract. You also need to keep, but you don't need to submit, a supporting list of individuals for your salary, wage, and FTE reductions, any documentation of any job offers that you made to restore people to their job, their refusals, documentation if you fired anyone for cause, or they resigned, or they requested an hour reduction. You need to keep that. And any documentation that you qualified for the FTE safe harbor, so you rehired people as of 6/30. And you have to retain all of these documents for 6 years from the later of the date of loan forgiveness or the date of full repayment of the loan. Now, if certain amounts of your loan are not forgiven, they're going to roll just into your loan, and you have 2 years to pay it off. You have 6 months where you don't have to make payments, and it's a 1% interest rate. So we're actually seeing a lot of people at this point in time who are saying, you know, it doesn't make sense for me to bring back my employees because I don't have a business. So I'm going to pay myself my salary amount. I'm going to pay my mortgage and, you know, whatever else it is that I have that I qualify for. I'm going to submit my forgiveness application for that small amount. And then I'm just going to take the rest of it as a loan because it's a good interest rate and I'll be able to use the money later on much for better business reasons than I can use it now. And so that's what I have to say about PPP loans prior to questions. So hopefully I answered some of the outstanding questions and concerns with that. And now we'll go to questions. I don't know how to get to questions.
Am I up,
You are.
Mary? I got a question on the new app requirement, which is going to get a ton of pushback. Thank you very much, Rachel and Diane. But this app requirement by the County of Sonoma is going to get a ton of pushback. And I suspect there's going to be a lot of people that just say, you know what, we're not doing it. It's an invasion. It's an overreach. So are these stop work notices that are threatened, are they going to be valid until there's a court case that is in place?
John, I believe that yes, they are going to be valid. The public health officer of Sonoma County has very, very broad authority in a pandemic like this. The construction field requirements require that employees are screened. So that was something that was required even before this new app that's going into effect on June 1st. If you do not have a screening protocol for your employees on a construction site, yes, the county or the city can come in and shut you down. They would give you a stop work order because you're not following the requirements.
But
now,
even if you do have a screening
Okay.
requirement, if you don't do the app, they can shut you down. If my IIPP, I revise it to have COVID-19 protocol in there, and my screening protocol is to put my forehead, back of the hand to a forehead to see if somebody's got a temperature. From what I'm understanding, Dr. May's saying that's not good enough.
Correct. And I think that one of the reasons why this app is going to be required on June 1st is so the county can keep track of this and that they can get a better handle on the rate of infection out there. And when you say that it's an invasion of privacy, the county has kind of gone out of their way to assure people that, one, we don't have any tracking information, and two, we're not requiring any type of personal information. And when you look at the questions that are on the app, that is true. They're not requiring that information. They're also saying that all the data that's collected is going to be deleted after 45 days. And because of all of this, I think any type of lawsuit against that this is an invasion of privacy, I think that the court would balance the public health needs versus the privacy issues, and they're probably going to come down on the side of the public health issues.
Okay, thank you.
Okay, and I had a question that I wanted to address, and it was specifically that employees who are over the age of 65 and have been self-quarantining, now that, and the question is, can we require these employees to come back to work And these are the employees who have underlying health issues like asthma or diabetes. And I wanted to address this. I briefly addressed it before. And the answer to that question is, as I said, under the Americans with Disabilities Act, these individuals have a disability, and their disability is the underlying health issue. And if their doctor is providing a medical certification saying it's my recommendation that these employees not return to work and that they continue to shelter in place at home, or, and I don't want to use the word self-isolate, because isolation is a very specific legal word that means that you actually have the virus and you have to stay away from people. Quarantine is also a very specific word that means that you may have contracted the virus, but you're under a period of quarantine for 14 days to see if you actually have it. But if the doctor is recommending that they stay off work because they're at higher risk, then you're going to have to evaluate it under that particular statute. And the best practice is to give them that time off, give them a leave of absence. And whether they would be available for unemployment under that particular scenario is because under the ADA, if they're out on a leave, it's an unpaid leave. Whether they would be available for unemployment is a question that's out there. When you're on unemployment, you're required to certify for benefits every 2 weeks. And a couple of the questions that are asked is, were you too sick or injured to work? And if you respond yes, then EDD is going to call you for an eligibility interview. And there's also a question that says, was there any other reason why you couldn't have accepted full-time work? And if the answer to that question is yes, because I have a disability and I'm in a high-risk group and my doctor has recommended it, once again, you're going to be scheduled for an interview. So whether they're going to be eligible for unemployment, the answer is probably, but it depends.
I was going to say there's a couple chat questions on there too.
Did you see the question from Janelle on the chat? I'm not sure if you can see the chat.
Oh, okay. I see. And the question from Janelle is, what if we implement this protocol and employees refuse to give the county their personal info? Are we forced to terminate the employee? The answer to that is that it's not personal information that the employee is giving to the county. What it is that on the app, the questions are, first you have to say what age group you're in. And it's really, are you under the age of 18, or are you between the age of 18 and 65? And are you over the age of 65? That's not necessarily personal information. The other information is that you need to give the zip code of your employer. And the other information is that you need to just describe what type of business your employer is in, for example, construction. That is the only personal information that's given, which isn't really personal. And then there's a series of questions. Do you have a temperature of over 100.4? Do you have symptoms, et cetera, et cetera? And you provide the answers. And if everything checks out, you get a badge that you give to your employer. Then the employer is the person who then turns around and reports that information to the county. And so, I mean, I can understand why people feel that this is an invasion of privacy, but it's probably not going to be termed that. So if an employee refuses to provide this information to you, the employer, and refuses to use the app, you're not necessarily forced to terminate that employee, but that certainly is grounds for termination. And I would sit down with the employee and try to find out what, really what their concerns are. The other question is, do Sonoma County orders apply to work sites in other counties if our office is based in Sonoma County? The answer to that is no, but most of those other counties are slightly more restrictive than Sonoma County. And I had referenced before a construction industry protocol, which incorporates all the Northern Bay counties and the CDC and the Cal OSHA regs. So shoot Mary an email with your contact information and I can email that out to you. And then I also see that there is a question regarding the PPP forgiveness.
Just a request to talk a little bit more about the debt interest qualification for PPP forgiveness and other than mortgage. So the act itself says that you can be forgiven if you make payments on any indebtedness or debt instrument incurred in the ordinary course of business. So any type of debt, as long as it's the liability of the borrower and it's a mortgage on real or personal property and was incurred before February 15, 2020. So really what that means is that it has to be secured either by real property, a house, a building, or by personal property, a copier, a car, some other piece of property. It has to actually be a secured interest in it. And then you are entitled to seek forgiveness of the interest that you pay on those obligations, not the principal portion of your payment, but the interest portion of your payment only.
I think you answered this question, but I was busy responding to other emails. If an employee refuses to go back to work when the business opens, and let's assume that they're doing everything within their power to provide a safe workplace and follow the protocol and so forth, but that employee says, I don't feel safe. I'm over 65, whatever the reason happens to be. What options does the employer have at that point?
Well, when you say I'm over 65 or whatever the reasons,
I was just using that as an example.
The reasons are important because
Okay.
if the reason is it qualifies for leave under the American with Disabilities Act, or if it qualifies for FMLA leave, then the employer is, kind of stuck. But if the employee just says, I'm too scared to come to work, and I'm not coming to work, obviously you have two options. You're justified in terminating that employee, or the better course of action is to give that employee an unpaid leave of absence with the explicit understanding that when they are ready to come back to work, they may not have a job anymore. This is happening to a few of my clients who are essential businesses, and they have implemented every single protocol. And there are employees who still say, hey, I'm not safe. I don't feel safe. I'm not coming to work. Or an employee says, I live with my elderly parent and I can't afford to, get the virus and give it to my elderly parent. So I'm not coming to work. Meanwhile, they need employees. So they have chosen to grant these individuals who are fearful of coming to work an unpaid leave of absence, but they have specifically stated this is not a job protected leave and your job will be filled. And when you're ready to return, you may not have a job. So you can do it in either of those two ways. And as I said, the better course is to just give them a leave of absence.
Dwayne has a question on the chat.
So do you add the virus protocol to an element of your IIPP or add a separate virus program in your safety manual? Your IIPP probably incorporates your safety manual, and it's kind of when Cal OSHA comes out and asks for your IIPP, you typically give them your safety manual also. So I would recommend that you put it in your IIPP, because that's exactly what Cal OSHA is saying on their website. They're not saying add a new section to your safety manual. They're saying this needs to be in your IIPP.
We have Jim Persons that's helping. With,
Yeah, I was gonna say, and I put it on the chat. We work with Jim Person, Safety Pride, to do IIPP, and I know, Diane, you put something on there with some forms that you got from another attorney. Really appreciate that. If people need help developing and integrating their IIPP with the COVID-19 protocol, and I'm sure some do, you can contact Mary at nceca.org, and we will put you in touch with the right folks, as well as the very generous Smith Dollar resources there. We appreciate that as well. And a big thank you to Diana Key and Rachel Dollar and Smith Dollar for letting you guys educate us today about all things to protect ourselves against claims. I think you're going to see some business, I'll bet, from this app requirement by the county. You can't believe my phone is just burning up because we put it on our social media page, and people are rightfully pissed about it. So I suspect you're going to see some folks that are trying to push and
Yeah, and the other thing that it's only Wednesday, we still have Thursday and Friday, so perhaps, you know, there may be somebody who's actually going to file a temporary restraining order asking for a preliminary injunction against it.
well, and we have an online Zoom conference tomorrow with 2 of the supervisors. This will be one of the major topics of discussion.
hey, John, Catherine's asking what the app is called and where to get more info.
It's on our Facebook page, and or
The Press Democrat, wasn't that on?
it was in the Press Democrat on
Yeah,
Monday.
Catherine, I'll send you a link to it.
Or you can also go on the App Store on your phone and just do a search for SOCO, that's SOCO, COVID-19 app.
Yeah, I see there's some other chat folks coming in here. Before we get to them, I also wanted to say this webinar has been recorded, and we'll make it available to all of our ECA members. And if you're not an ECA member but you want to avail yourself of it, just ask Mary at nceca.org, and I'm sure she'll be happy to send you the link to
There.
that. So I'll back off. You got some more chat questions on there or comments?
We don't see any more.
I don't think there's any more chats, John.
Oh, we got them all. Okay.
Okay.
Well,
and
it's
if-
4:30, so I want to thank everybody that participated. And again, we'll continue with these types of webinars next month. In a few weeks, we'll have less than a week, I think, if we can pull it off. We're going to have one on the new workers' comp rules, which are, again, a huge burden to employers. And they'll be quite a surprise to people that aren't up on that. So look for us on our Facebook page. And if you get our newsletter, it'll be in our newsletter out tomorrow. So again, Diane, Rachel, thank you guys. Thanks to all of our sponsors, BKF, Smith Dollar, and our sustaining members. And Mary, thank you. We're out.
Well done. Thanks, Diane and Rachel.
No, you're welcome.
Thank you, guys.
Let's see. I'm going to stop recording.